Good morning, everyone, and welcome. Thank you for attending episode 4 of our webinar series, Commercial Collections Corner, which touches on all things commercial collections. Today's topic is domesticating foreign judgments. My name is Nick Rohner, and I'm an attorney here in the Cincinnati office at Weltman, and I'm going to be the moderator for today's session. Just to give you some background about me here, I mainly handle collection litigation matters, both commercial and consumer. Inside of those two areas, I specialize in collateral recovery. I am licensed in Indiana, Kentucky, and Ohio, which keeps things pretty interesting, sort of juggling those 3 states and all of the counties inside of those states. Two of my colleagues are on with me today, Madison, who's going to be helping with the slides, and also Owen, who's going to be monitoring for your questions, and he'll send them over to me if you have them. I just want to thank both of them in advance for their help. So before we get started, I would like to go over some basic housekeeping. Please type your questions into the questions feature. I may answer them midstream. I may also wait to the end. So we'll see how we kind of handle those as we go. The webinar is being recorded, and you will receive a link after the webinar is over. And you will also receive at the end of the webinar a brief survey, which we would appreciate you sharing your feedback from today's session, and let us know what future topics you might be interested in. We do plan to conclude by 12 o'clock. Honestly, domesticating foreign judgments is kind of a niche topic, so I doubt I'll be able to talk for an hour. So, but we will definitely end by 12 o'clock. So let's get started. Madison, if you could go to the next slide, please. Okay, this is just to give you an overview. So Madison, if you could go to slide number 3, please. There we go. Oh, that's number 4. Oh, just give us just a second here. There we go. Okay, our overview, I'll just go over it here. We're first going to talk about the basics, okay, sort of the process. Then the basics of domesticating foreign judgments. Then we're going to go over the process of domesticating foreign judgments, followed by enforcement of a foreign judgment. And then at the end, towards the end, we'll hit some odds and ends, and then of course end with any questions that we have. I will mention, and I've already alluded to it, that I am licensed in 3 states, Indiana, Kentucky, and Ohio. I will reference throughout different things about those 3 states, and I certainly understand that most of the people on this are not in Indiana, Ohio, or Kentucky. We have people from all over the country, which is great. So obviously in your jurisdiction, things might be different, but I'm going to raise these examples just to show that states can differ in the processes and procedures of foreign judgments. Okay. All right. So moving on to just something, the most basic of the basics, and that is, what is a foreign judgment? Okay. A judgment, by definition, it's a judgment made by a court in a jurisdiction different from the one where enforcement is sought. It is also known as a sister state judgment, okay? And it's only used in the enforcement phase. So it doesn't exist until you actually try to domesticate it and enforce it. Otherwise, it's just a judgment. Okay, so it's a judgment. So for instance, if I'm in Ohio and somebody has a judgment in Illinois and they want to domesticate that judgment in Ohio, that is now going to be a foreign judgment in Ohio. All right, and this only applies to US judgments. Okay, judgments in the United States and its territories, that for purposes of the term foreign judgment, we are only talking about US judgments. When you hear foreign judgment, it's easy to think about foreign countries. And we actually will touch on that near the very end. There is something separate for that about the recognition and domestication of foreign country judgments. but for purposes of this, the majority of this webinar, we are just talking about United States judgments. And just keep in mind also, as we talk about the very basics here, is that there's only one judgment originally, okay? That even though we're going to talk about domesticating that judgment in other jurisdictions, there's only ever one judgment, one original judgment, okay? That's where the original case was filed, that's where it was litigated, and that is the original judgment. So even if we move it around to all 50 states, there's still only one original judgment. Okay, Madison, if you could go to the next slide, please. Okay, so now that we've covered sort of the basic definition of a foreign judgment, let's talk about what is the basis, the legal basis for domestication of a judgment. And you probably didn't think we talk about the Constitution in this webinar today, but we're going to, because that's where the original basis comes from. There is something in the Constitution, there's a provision, Article 4, Section 1, called the Full Faith and Credit Clause. And that reads, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And that's been interpreted over the years to include judgments. And so that is where the original basis for being able to domesticate a judgment in another state comes from, the full faith and credit clause. Next slide, please. Okay, so now that we know what our basis is, that we're going back all the way to the Constitution, we know we can do this. So as we start talking about how we can do this, how is that governed? Okay, what governs the mechanics of domesticating a judgment? And so that comes from the Uniform Enforcement of Foreign Judgments Act, good old UAFJA. If you've never heard of it, it is it's an act that originally came around in the 40s. It's been modified several times since. It's now been adopted in 48 states. We'll talk about what, if you want to just think about, maybe if you can guess the two states that it's not. One's somewhat predictable, one is not. But prior to 1948, things, it sounds like, were pretty messy as far as trying to enforce judgments from one state to another. And that is why this Uniform Act was created, and then it was up to the states to adopt it. And it took some states longer than others. Like I said, it's been sort of tweaked over the years, but now we've got it in 48 states. The only two states where it's not has not been adopted are California, which is somewhat predictable because California tends to, they do a lot of their own stuff in the legal realm, and then also the other one's Vermont, which is extremely random. But in California, they just have their own procedure. You can still domesticate a judgment there. You just have to follow their procedure, which doesn't exactly follow UAFJA. And then in Vermont, they actually you have to file like a domestication action, like a special procedure there as well. There have been courts out there that have described UAFJA as merely a device to facilitate the enforcement of foreign judgments. So again, it's not there to do anything more than just sort of set a course, set a procedure, a basic structure for domesticating a judgment. Okay, next slide, please, Madison. All right, before we get into sort of the process involved, we're going to talk about why would you do this? Why would you look to domesticate a foreign judgment? And there's three main reasons. The first one, which I think is the most common, which is that your judgment debtor has moved. It's a very mobile country, obviously. People move all the time. They move out of state. They move across state lines. For instance, if you live in a city like Cincinnati, where I am, I mean, we're right across the river from Kentucky. we're also just 30 minutes from Indiana, and so people around here do move around amongst those 3 states all the time. And so let's say you have an Ohio judgment, your defendant moves to Kentucky, or let's say they move to Arizona. You may need to domesticate the judgment there in order to try to collect from them. The second most common reason, and we certainly see this in the commercial setting, is if you originally had a forum selection clause. And what that means is, the commercial loan you have, let's say you have the debtor is in their business or in Illinois, but the loan, the bank is based out of Ohio, and so often there'll be a forum selection clause, which means that any dispute about that loan must be litigated in a specific forum, likely the forum where the bank is located, where their headquarters. So let's say Hamilton County, Ohio, where we are, that's where the forum would have to be. So if there's a dispute about the loan or they just failed to pay, the lawsuit would be brought in Hamilton County, Ohio, even though the debtor is in Illinois. And let's say we get service by certified mail on the debtor in Illinois. They don't respond. We obtain a judgment in Ohio. Then we're going to look to domesticate that judgment relatively quickly into Illinois, where we can exercise what options we have for collection there. Okay, so that's the other thing you see most common in the commercial setting would be a forum selection clause. And then the third reason that we see sometimes is to attach a specific asset or potentially wages of the debtor with that or in another jurisdiction. So for example, we're in Ohio, the debtor's in Ohio. We get a judgment against the debtor in Ohio. However, the debtor actually is working for a company based out of Arizona. Well, you can try to have the court in Ohio issue a garnishment order and send it out to Arizona for execution or essentially enforcement, but sometimes those companies will not honor that because it's not coming from an Arizona court. And so a reason to domesticate would be just to essentially attach the wages of the debtor. Even though the debtor has no other contacts there, they don't reside there, most states will allow you to domesticate a judgment just to attach assets. Okay, so we can move on to the next slide, Madison. And that's going to be, we're going to start talking about the process of domesticating a judgment. So the first step one, is we decide we want to domesticate our judgment somewhere. What do we do? So first of all, we're going to obtain an authenticated copy of the judgment. All right, so what does that mean? Basically, an authenticated copy is going to show the next court that this is real. This document is a real document issued by our court. Okay, and the main principle here is authentication prevents fraud. This document is what it says it is. It's being issued. It was issued by the court that it appears to be issued by. So what kind of authenticated copy do we need? Well, there are a couple different types. Most people have heard of certified copies. Certified copies of documents apply not only with courts, but with other types of things in your life. You may have at some point need to get a certified copy of your birth certificate. It's basically a way of a government agency certifying, a document, usually by a stamp and a signature, that this is in fact a real document that we issued. Okay. Now, the thing about domesticating judgments is that is normally not going to be enough. A certified copy from a clerk's office by itself usually will not get a judgment domesticated in another jurisdiction. I can't speak for all jurisdictions, but that is the majority rule, that a certified copy is not enough. Okay, you will just want to check on that. It could be enough. but most of the time it's not. What they are looking for is something called an exemplified copy. That's also known as a triple seal, okay, document. So what exactly is that? You might have heard of that, but it's not clear what that actually is. So the way it works with an exemplified or triple seal, it's basically signed 3 times. Okay, so these are these additional layers of authentication to show that this document is what it says it is. And the 3 signatures, if you follow me here, the first is the original stamp and signature of the clerk saying this is a judgment from our court. So just a standard, it's almost like the first step, the certification. It's just the original stamp by the clerk. But then the judge then provides a second signature, okay, saying that, yes, that clerk that signed it is the clerk of our court and authorized to sign, and certify documents. So the judge, usually it's the presiding judge of the court, will come in and sign as well on the same, there'll be a page and it'll be literally 3 signatures. And then there's a third signature, which is the clerk comes back again and certifies the signature of the judge. Okay, so you have clerk, judge, clerk signing this, and that's why it's a triple, and each one sort of signs and seals. So the third one is the clerk saying, yes, that judge is the presiding judge of this county, basically. So I mean, to me, if I'm being honest, it seems like a bit of overkill. Especially the third one. I don't know really why you need the clerk to certify that that's the judge. I mean, if the clerk and the judge are kind of in on it, then the third one's kind of meaningless, but that's just my opinion. But anyway, that's where the third, that's the triple seal concept, okay? So if you would request that from the court, they'll know what it is. We shorten it here to ECOJ, which is just exemplified copy of judgment. That's kind of our lingo here, but that's what you would order from the court. And you would do that in one of 2 ways. You would either order it online. Some counties now actually you just go on the website and you can order a document like that online. Or a lot of courts still, you request that by mail. From our office, we would just send a cover, like a letter. And of course, there's a fee. And so you would, you need to find out what that is. Normally, the fee for an exemplified copy of a judgment is relatively small. It used to be like $3 around here. I think now it's up to 5, maybe 10, but you're looking at a pretty low amount just to get this. And then, of course, you send it off, the request, or you make the online request, and then you just have to wait for that to show up, because without that, you can't move forward with the domestication process. So next slide, please. Okay, moving on to step 2 in the process. So you've got your ECOJ in hand, okay, and now it's time to actually file it or send it off for filing in the new court, okay, in the new jurisdiction. So you're first going to want to find out, well, how do I do that? Do we electronically file it? Because so much is done now electronically, or just do we do it by traditional mail? Now, in theory, it should still be done, and it's still mainly done by mail, okay? And the reason why is because obviously you're dealing with a triple seal document. I mean, it has 3 original signatures, 3 seals on it, and so it makes sense that you'd mail that in. But because e-filing has become so prevalent, there are some states now, Indiana being one of them, that actually has you e-file the ECOJ along with the other documents. And so I find that interesting, because you just went to all that trouble to get the ECOJ, and then you're essentially filing a copy of that. So what we do is, we'll file the electronic copy, then we'll kind of hold on to the original in case there's ever any issue there. But yeah, so that's something that you'll want to find out as you start this process. The filing fee for this is going to be more. It's going than just getting the copy. It's going to be like filing a new complaint usually. So usually just to make a prediction, whatever jurisdiction you're filing in, it's going to cost about the same as it would cost to file a brand new complaint to file this domestication paperwork. Okay, but you'll again want to check with the jurisdiction you're heading into. And then you're going to file an affidavit, and this comes out of UAFJA. This is like a standard thing. UAFJA just requires that this affidavit be filed, and it has the name and last known address of both the judgment creditor and the judgment debtor. That's basically all that's required on it. It's not complicated, but that's something that the courts will require you to do when you file your ECOJ. So next slide, we'll move on to step number 3. Okay, and so this is the other document that's required in the packet that you submit to the court. And it's called a notice of filing a foreign judgment. And this notice, the concept behind it is that it's being sent by the clerk out to the debtor, telling them, hey, a foreign judgment has been filed in our court. Okay, but in reality, the clerk may be issuing it, but you're the plaintiff's preparing it. So you're always going to want to have that notice prepared, and you'll submit that with your other paperwork. In some states like Ohio, the clerk will then sign off on your notice that you prepared. And all that notice basically tells the debtor is that, hey, there's been a foreign judgment entered against you. It's going to give them the name and address of the judgment creditor and the attorney that filed it. And then usually it's going to give some other instructions too about how long they have to potentially respond, how they could go about staying enforcement of the judgment. And that's going to be included on that notice. So some notices, in some states are longer than others, but the only thing that has to be on there is the name and address of the judgment creditor and their attorney. But often there are other instructions as well. Next slide, please. Okay, so we've talked about the process. We're kind of pretty much done with the process. It's been accepted. The clerks, filed it, stamped it, sent out the notice to the debtor. Okay, so then at that point, the foreign judgment has been recognized. Okay, and there is a difference though between recognition, which is pretty easy, and then the enforcement. The enforcement is kind of the next phase, and it's just something that we need to consider separately. Okay, in part because enforcement waiting periods can vary by the state. So even though UAFJA provides sort of the structure, states are allowed to go in. They go in and kind of like change it slightly, depending on, how long they feel, for instance, in this circumstance, that a debtor should be allowed to respond. Okay, and this is a perfect example of some of the little tweaks that states will do with UAFJA. There'll be differences. So in Ohio, the notice actually will say this, that you have 30 days from the date of this notice to file any response that you're going to file. Okay, Kentucky, it's 20 days after the original foreign judgment paperwork is filed. And so, it'll say right on again, the notice they get, it's 20 days from the date that this document was filed. And so when the debtor gets the copy of it, they can look at the file date and count 20 days. That's how long they have. Indiana takes a different approach. All they say in their version of UAFJA is that you've got 21 days from the entry of judgment in the judgment's original jurisdiction, which isn't really long. And often it's already passed by the time we even domesticate it. You'd have to move pretty quickly to get a judgment and try to domesticate and get everything together, get the ECOJ and everything, and have it filed even within 21 days. So practically in Indiana, you can just execute immediately. There's no real waiting period in Indiana. Next slide, please. All right, so during that waiting period, what can a debtor do? Like, what can you expect if they want to challenge what you're trying to do here by domesticating this judgment? And honestly, it's very difficult for them to put a stop to what you are doing. Okay, there's only limited things that they can do, because keep in mind that there's only the original judgment that case was already litigated in the original court. domestication doesn't create a new opportunity for the debtor to raise defenses and things like that. Those have all been dealt with back in the original jurisdiction. So that's why the reasons that it could be stopped are very limited. Okay. So what are they? Well, the debtor can show that there's already been a stay of execution. Okay. And that's been issued in the original court, or they filed an appeal in the original court. And not only on top of that, they've got to show that there's actually been security furnished, meaning that there's been like a bond posted or something to cover payment of the judgment. Okay. And a lot of times that hasn't been done. So it's rare that we see that there's really been a stay of execution issued in the original jurisdiction. And then secondly, they could try to actually get a stay of execution issued in the new jurisdiction. But like I mentioned, there are very limited reasons to why a judge would allow that, okay? Because that judgment, the original judgment's already been entered. The case has been decided on its merits. And so now it's just a domestication and collection situation. So, but when we get to the next slide, we'll talk about a possible reason why you could get a domestication stayed. So Madison, if you could move to the next slide, please. All right, and the most common reason that we see when we're domesticating a foreign judgment, let's say in one of our jurisdictions, if I'm handling it, is someone will file something saying, hey, I was never served in the original jurisdiction. I live here in Ohio, and you're trying to domesticate this judgment against me from, Nebraska, and I never received word of it. I never was served properly by under Nebraska law, and so that judgment's invalid. You shouldn't be able to enforce that in Ohio. Okay, so they'll raise that to the court. Normally, though, what the court will do, and we may help them with this, is push them back, because it could be a valid defense, but is to push them back to the original court, okay, to file for relief, okay, because like I mentioned before, there's only one judgment. The original judgment is the judgment. So if you're going to challenge the judgment, that needs to be done in the original jurisdiction. And so what they should be doing is in going back to Nebraska and filing a motion for relief from judgment in Nebraska, okay, based on a service argument. And usually a judge will give them, let's say, 30, 60 days to file that motion. And if they do that, then they'll put a stay on the enforcement of the foreign judgment in Ohio, okay, which is fair. I mean, we don't normally challenge that. If there appears to be, a true issue there that needs to be resolved in the original court. The other reason you could see, your other reason that you could see is payment, right? That's the other thing. Occasionally, someone will come back and say, "Well, I already paid this or settled this, in the original jurisdiction. Why are you trying to domesticate this now?" And it's possible. I mean, you do sometimes see that where, maybe they did, it took a little bit of time for the paperwork to flow through to get to us, the ECOJ and all that, and maybe they did resolve it, maybe a couple weeks ago, and we weren't aware of that. So when that happens, then that obviously can resolve it as well. Okay. A question came through, which is the waiting period per state the same for judgment versus domesticated judgment? Okay. Well, for purposes of this, we were just talking about domesticating the judgment, how long you've got to wait. In a regular, the original judgment it's original judgment case, then if we're talking about service of the complaint before the judgment's entered, yeah, that often is a different amount of time that you would have to respond. And so, like for instance, in Ohio, it's 28 days as opposed to 30. And so you do sometimes see some differences there. Maybe not large differences, but yeah, if it's the amount of response time to obtain the original judgment, that can be slightly different. And so you will want to check on that. Okay, hopefully that answers your question. Madison, can we go to the next slide, please? Okay, and as we're also talking about enforcement, the duration of the foreign judgment, this is very important, okay? Because you gotta know. So when I say that duration, it's how long does this last? Like how long can I try to collect on it? Um, because obviously collection can take months, years, sometimes, decades. I mean, it can take a long time to collect on a judgment sometimes. And so you need to know first, okay, how long is the original judgment good for? Okay, so let's say you got an Ohio judgment and now we're domesticating it in Illinois. Um, how long is my original Ohio judgment good for? Do I need to do anything to keep that judgment active? Is it going to go dormant at some point? Do I need to renew that every so often? Okay, so that's the first thing that you need to keep in mind is that you never want your original judgment to go dormant or inactive. Okay, because that could jeopardize the ability to collect on your foreign judgment. And so there's a tendency once you've domesticated it just to concentrate on what's happening in the new state, in the sister state, but we can't forget about what happened in the original jurisdiction. So that judgment needs to be kept alive. Okay, then we also need to know about the law of the sister state, okay, and how long are judgments generally good there, all right? Because we may need to also file something in the sister state jurisdiction every few years to keep the judgment active in that state. Okay, it could be, it depends on the state. It could be like a renewal type of judgment filing. I mean, the states are really differ on this. And then there's, of course, the interplay between the two that you need to keep in mind. And I brought this up because we had a situation that our national forwarding group came across where we were trying to take an Indiana judgment and domesticate it in Mississippi a few years ago. And the issue at that time, Mississippi, was that judgments were only good or they would only allow a domestication of a judgment that was 7 years old or less. So if it was more than 7 years old, you couldn't domesticate a judgment there. And if the judgment had expired, they wanted like a renewal judgment to have been issued. Okay, like another judgment filing, which some states allow. And our judgment was from Indiana, I think it was 12 years old or something like that. And Indiana doesn't have a renewal type of procedure, especially at that 12-year mark. And so there's no way, Indiana judgments are basically collectible in perpetuity as long as, you know, that the creditor validates that it's not been paid. So there really isn't a renewal process in Indiana. So we just have the original judgment and it's 12 years old. And so we were unable to domesticate that judgment in Mississippi because of the age of the judgment. And so that's sort of how the interplay between these two jurisdictions, the original jurisdictions and the sister state jurisdiction, can come into play. And I know there are other states out there that have limits on how old a judgment can be for domestication. So you're going to want to know that. And if you've got an older judgment, just keep in mind that you may run across some roadblocks in trying to domesticate that judgment. Okay, next slide, please, Madison. All right, just a small topic here in the enforcement realm, and that are judgment liens. A lot of the times when we domesticate a judgment somewhere else, you're looking to place a lien on a piece of property. And so it's just something to keep in mind that in some states, the lien is going to be automatic once you file your foreign judgment. It's just sort of part of the process, the clerk's process in filing the foreign judgment. So for Ohio and Indiana are like this, where when you when you domesticate your judgment, it automatically a lien will be established in that county, which could attach to property of the debtor. But in other states, you may have to go a second step and do a separate filing. Kentucky is an example of that, where we would have to file, if we're domesticating into Kentucky, we'd have to do a separate filing with the county clerk to establish a judgment lien. Okay, next slide, please. Interest on foreign judgments is a topic that I wanted to discuss it today because there's a few things to keep in mind here. And there's basically two ways to go about this, or there's two main rules here that in some states will follow one and some the other. But most of the states sort of keep it simple, and is that when you domesticate judgment into that state, the foreign judgment will accrue interest, okay, post-judgment interest at the rate that is in accordance with the original jurisdiction. And so, like for instance, in Indiana, if we domesticate a judgment into Indiana, where there the statutory rate of interest cannot exceed 8% on a normal judgment. However, if we're domesticating, let's say from Ohio, and we have a contract which in Ohio allows the contract rate post judgment, and it's 13%, we can actually domesticate the judgment into Ohio and run interest at 13%. We are not required to lower the interest rate to 8% just because that's Indiana's law. Okay, and most states follow this rule, and it makes it very simple as well. Okay, it makes it very simple to figure out on your end. Is that, hey, we just keep the interest rolling, right? We don't change anything. Calculation stays the same. We just keep the same interest rate. All right, the minority rule is, and just a few states follow this, which is that your foreign judgment, you can run it at the interest rate of that state, okay, that where you domesticate. The sister state is the rate of interest that you're allowed to run it at. So some creditors might think, oh, that could be, well, I mean, if it's a lower rate, then you just have to lower it, and that's the way it goes. But if you have a higher rate, some creditors might say, oh, that's great. We're gonna raise the rate now. We're gonna collect more interest. Okay, but beware of this because I ran across, I think, a Pennsylvania case where a judgment debtor did have to pay sort of this higher rate of interest on a foreign judgment, but then after they paid it, they went back to the original court where the judgment is rendered and actually was able to collect from the judgment creditor, get a refund of that excess interest, because they said, hey, the original judgment is what I paid, and now I had to pay more in this foreign jurisdiction. Why I shouldn't have to do that? And the court agreed, and they were able to get a refund of that interest. So I think sort of the moral of that story is just, if you go into a state and they do allow a higher rate of interest, I wouldn't bother with that. I would just stick with what you already had and just collect that interest. A question came through which says, does this apply to AOJs as well? And so I'm assuming that means assignments of judgments. And I'm not sure, I'm just seeing that question, so I'm not sure exactly in what context. But I will say that it's actually a good question in general as far as assignments of judgment. Okay, so let's talk about that. So if your judgment gets assigned after the judgment was domesticated, okay, what I do in that circumstance is we'll file basically two assignments of judgment. We'll file one in the original court. You definitely have to file one in the original court, okay, because again, that's where the judgment, there's only one judgment and that's where it is. So we'll file the AOJ there, but I also will file one probably in the foreign jurisdiction as well. Just to be safe and just so everybody's sort of on the same page, and then we can make sure our judgment creditor is listed properly in the caption in the foreign jurisdiction. So that's actually a really good question. And so that's how we handle that here, is we actually file two assignments of judgment if the judgment's assigned after domestication. So I hope that answers your question. Madison, can we go to the next slide, please? Great. Satisfying a foreign judgment. So let's say everything goes well and you get paid, paid in full, or you settle, and you're ready to satisfy the judgment after it's been domesticated. Just the only thing I wanted to mention on this is make sure you file two satisfactions, one in the foreign jurisdiction, in your sister state jurisdiction, and the other in the original jurisdiction. Sometimes it's easy just to file one, usually in the foreign jurisdiction, because that's where the file's being worked, that's where the money's being collected. And so we're like, yay, it's over. we'll close our file, but just make sure that you notify maybe the original law firm who took the judgment. I mean, it could have been, 8 years ago, but there will be an original judgment out there. And that judgment does need to be satisfied as well. So just make sure you're satisfying both judgments if it's been paid. Okay, next slide, please. Okay, another kind of a niche top item here. Federal court judgments. How do those work as far as domestication? Well, if it's you're taking a federal court judgment, let's say a bankruptcy court judgment from Ohio, like an adversarial judgment, non-dischargeability judgment, something like that, and you want to domesticate that into Illinois. It's really just a standard domestication. You can get an exemplified copy from a federal court, and you can just go ahead and file that, just like the paperwork be just the same as a regular domestication. If it's going inside the same state, that's why I wanted to mention this. Sometimes if you're going from like an Ohio federal court to an Ohio state court where you're wanting to file it for execution purposes, you need to find out, make sure the procedure for that. Well, actually in Ohio, it's simple. I think you can just file it. It's been a while since we've done one of those, but I believe you just file it normally without a domestication process. I think you could just literally file an exemplified copy with the clerk's office, and I think they'll assign a case number, sort of give it the in-state treatment. But then some other states like Indiana, they actually want you to domesticate the judgment, like go through the foreign judgment process, even if it's an Indiana federal court going to an Indiana state court. So, again, a bigger filing fee and the notice and the affidavit and all that stuff. So you just want to check that if you have a federal court judgment that you're wanting to domesticate, what the rules are as far as if you're trying to do it inside the state you're already in. If you are going out of state, it's just a standard domestication. Okay, next slide, please. All right, there are some, hiccups with just a few different types of judgments, because overall it's a pretty streamlined procedure that's been created by UAFJA, but there are states that have taken a look at certain types of judgments and make it a little more, they make the procedure more challenging. New York and Connecticut are just two examples that you can't use the streamlined procedure to investigate a default judgment. They have their own procedure for those types of judgments. Now, a lot of judgments that we get in the collection arena are default judgments. So this really is something to consider and to understand that kind of limitation and to know what the process would be in those states if you're trying to go into those states to domesticate a foreign default judgment. So I wanted to throw that in there, just more food for thought. And then next, another example is Indiana. They do not allow you by statute to domesticate a cognova judgment. For those of you who are unaware of what that is, it's something that exists in the commercial lending world. Their cognova notes are notes that basically, when a debtor will sign it, there'll be language on there saying that if you default, we have a right to go to court and enter a judgment and basically answer the complaint on your behalf, admit a liability, and enter a judgment without any kind of court hearing. There's no due process or anything like that. It's a great tool for creditors. We've certainly enforced plenty of those in Ohio for our clients. But some states really don't like those because there isn't due process, things like that. And Indiana is one of those states. Not only do they not like cognova notes, it is a crime to have one executed in the state of Indiana. It's a misdemeanor to have someone execute a cognova note. So going along with that, they also do not allow you to domesticate a cognova judgment from another state in Indiana. Okay, so they are really disfavor cognova notes and cognova judgments in Indiana. Okay, next slide, please. All right, we're going to end kind of with this topic because I think it's pretty interesting. And these are we talk about foreign judgments from the U.S., but what about foreign country judgments? Can you enforce, or can you domesticate and enforce a judgment from another country? And believe it or not, they have established something called the Uniform Foreign Country Money Judgments Recognition Act. Okay. And what this is, it is a way for, and many states have adopted this. Now, not all of them, not as many as UEFA, but a fair amount have. And it's a way to, it's a process to domesticate a foreign country, a judgment from another nation. But there are limits, and we're certainly going to talk about those. It only applies to money judgments. All right, so you can't, you know, there's other types like possession only judgments, things like that. You're not gonna be able to domesticate something like that. Any kind of declaratory judgment, which you might be able to do that here. You know, move those judgments around. You can't bring one in from another country. Okay, you can only bring in a money judgment. Okay, but it can't be a tax judgment. It can't be something that imposes like a fine, or it can't be a domestic order, either child support, um, you know, alimony, something like that. You can't domesticate one of those from a foreign country. It applies to only final and conclusive judgments. And when we go to the next slide, we'll kind of talk about what that means. That a foreign country judgment is not conclusive. So remember, it only applies to conclusive judgments. It's not conclusive if the foreign country did not have personal jurisdiction over the defendant. Okay, and that's a big one, obviously. So, you know, if somebody, you know, you're sitting there and someone tries to you know, a judgment debtor is having a judgment domesticated against them. Someone's attempting to, you know, domesticate a judgment from Latvia, and they say, I've never been to Latvia. I've never have any, you know, communication, correspondence, any connection with Latvia whatsoever. I've never been to Latvia. Well, there's a pretty good argument that that court never had personal jurisdiction over the defendant, and that would certainly be a good defense to the enforcement of that foreign country judgment. And then this last one here, which you know, I think this is an important one here, is that the judgment, it's not conclusive if a judgment was rendered under a system that does not provide impartial tribunals or procedures that are compatible with the requirements of the due process of law. And, you know, while there's not a sort of list of countries out there that, you know, that provide impartial tribunals, I think, you know, we have a good idea of kind of what those are and what countries do not. And so I think that, yeah, I understand why, you know, that we're not here going to recognize judgments from certain countries where due process rights are very, very limited. So I think that's extremely fair. So that's kind of how we're going to end things. It doesn't look like we have any additional questions today. So I'll just kind of close by saying thank you for attending today's seminar or webinar. You know, we hope you found the presentation helpful and informative. As a reminder, there is going to be a survey that pops up when this is over, and we'd love to get your feedback on it and know if there's any other future webinar topics that you'd like to see. I'd also like to share that we have actually a library, a complimentary library of over, I think it's 40 plus now, webinars that you and your team can view on demand. We've got topics such as collateral recovery, bankruptcy, I think real estate, and a lot of other topics in the creditors' rights area. So you'll get actually a link to that library when we send you a follow-up email. And otherwise, again, thank you for attending, and I hope you have a great rest of your day.